Hey there, welcome to our AP Legal Zone podcast, brought to you by AP Lawyers. We are your top fix for all weekly law updates, including family, immigration, wills, and estates law. Just a friendly reminder, we are not your lawyers, and everything contained in this podcast is for entertainment purposes only and not to be construed as legal advice. Be sure to subscribe to our podcast so you can stay connected with any updates and get notified about our new episodes.
Hi there, I'm Angela Princewill.
And I'm Sherine Abdi.
Our topic today is spousal support. So Sherine, what is spousal support?
Well, that's a tough question. Spousal support, difficult to explain in one sentence, but ultimately it's the money paid to one spouse after they separate. The simplest way I can explain it.
Yeah, so the way it's described in the Family Law Act essentially is that every spouse has an obligation to support him or herself and to support the other spouse as well. And this is not just in a vacuum. Obviously, it's based on the needs and the extent that a person is able to do so. But now when we talk about spouse, who is a spouse?
So a spouse, as defined by the Family Law Act, is really a person who's either married or a common law spouse for at least a period of 3 years. And if you have a child, then only a period of 1 year.
Okay. So now that you know what spousal support is, I'm just joking there. We're just getting started. I was gonna end it like, now you know what spousal support is, you know what a spouse is. But really, when you're talking spousal support, it really in its simplest form, we're usually looking at one party earning more than the other, and sort of balancing out and providing for that other party following separation. And some of the factors under the Divorce Act that the court's required to look at is, how long did you guys cohabit? So this is not just the length of the marriage, and this would, the duration of cohabitation, the duties, the functions that were performed by each spouse during cohabitation, and any agreement that you guys have that deal with the issue of spousal support. So I know before the podcast started, Sherine had mentioned something like it's not a right. So when you talk about child support, is that automatic right there? Sherine had said it's not a right. You have to be entitled to it, right?
Yes. And on a case-by-case basis, entitlement will be dealt with.
Yeah. And so when we're thinking entitlement, again, I like to refer back to the Divorce Act, and you're looking at sort of what's the objective of spousal support? What is the courts trying to do here when they're making these orders for spousal support? And so there's sort of 4 headings here, and every order for spousal support is supposed to recognize any economic advantage or disadvantages to the spouses arising from the marriage or its breakdown. It's to apportion between the spouses any financial consequences arising from the care of any child of the marriage over and above any obligation for the support of a child of the marriage, relieve any economic hardship of the spouses arising from the breakdown of the marriage, and insofar as practicable, promote the economic self-sufficiency of each spouse within a reasonable period of time. So this is a lot, and really in these statements sort of cover sort of the basis of entitlement we usually say to spousal support. But before I even get technical there, I want us to kind of talk a little bit about these objectives. So when we're talking about economic advantages and disadvantages of spouses arising from marriage or its breakdown, the most obvious one I would say is probably one spouse subordinating their career for the other, right?
Exactly. Or one spouse, even just as a purpose of that, having a larger income than the other spouse.
And it's if you're looking at it from the outside in, it's like, well, they worked hard, they have more money, what's the big deal? But marriage is a legal concept. I know these days it looks like it's just a romantic idea, and yes, it is 99% romantic until there's a separation, and we're reminded that it's a 100% legal process. So with that comes certain um, responsibilities. But the truth is, when people are in a relationship, they structure their affairs differently. So, two people, I mean, hey, look at Michelle and Barack Obama, for example. They're both Harvard Law graduates. One was encouraged and seen through politics, and the other person took more of a first person role, first lady role, right? If we look at it just on paper, whatever he did, she could also have done. So, well,
yeah,
girl power there.
That's the civilian career, and that's the economic disadvantage clearly in that case.
Yeah, so if I mean I don't know how much the president gets paid, but if she, that if he's getting paid an amount that she's not, and that's an economic disadvantage right there. When you talk about the financial consequences arising from the care of any child of the marriage over and above an obligation for support of the child. So what we're talking about here is a lot of times people are fine with paying child support. They're like, well, I'm going to support my child. I mean, they're my kids. I'm fine with that. But spousal support recognizes the fact that just having the children in your care alone, there are financial consequences that may not be adequately dealt with just by child support alone, right?
Exactly. It's especially if on the standard of living, if there's there's a clear disparity between the incomes and their standard of living for the children.
And I like that you said that, because it reminds me, and I think we've talked about this in an earlier episode as well, where people think that the fact that they're paying child support, or maybe they have equal parenting, they may not need to pay child support. But they forget that, yes, while equal parenting might reduce the amount of child support you have to pay, it increases the spousal support you might have to pay, because again, we don't want kids having steak in one home and barely having chicken fingers in another, right? So the other area, that we want to also to kind of continue down this list is the relieving of any economic hardship that the spouses that arise as a result of the breakdown of the relationship. So I mean, I think that's pretty
self-explanatory.
Yeah, that loss of standard of the family standard of living, or now just essentially having your only source of income in some cases taken away.
So having obviously like a different lifestyle, and being very accustomed to that standard of living, even just from your relationship alone, taking those lavish vacations somewhere, and having multiple homes and things like that. So that's a clear, very economic disadvantage. You're going to have to subdue, your financial lifestyle a little bit.
Yeah, and I think when it comes to the care of the children, there's, especially when one parent has primary care of the children following a breakdown of the relationship, well, the economic hardship could continue, because if you were the primary caregiver during the relationship, chances are you're fighting very hard to continue to be the primary caregiver after the relationship, but that could affect your ability to work, right? And so that economic hardship continues. It's not as easy as just go get a job. Well, we know that having a job and not having any childcare responsibilities is a completely different ballgame from somebody else that's able to maybe work overtime and climbing their career and get those promotions and things like that. And so the last, and maybe one of my favorite ones, is insofar as practicable, promote the economic self-sufficiency of each spouse within a reasonable period of time. So there's three things there. First, it has to be practicable.
Yep.
And then you have to promote it. So it doesn't just mean that the purpose of the spouse is supposed to help promote that self-sufficiency, and it has to be within a reasonable period of time.
Yeah. So for example, if you have been the primary caretaker, and let's say you don't have a college degree, and in that period of time that spousal support so is that it's reasonable and that you're entitled to it, that maybe you want to go back to school and there's some support element that's paid for a period of time to allow you to be self-sufficient. Or even if you're dealing with young children, at least for the period of time while you're dealing and maybe taking on that primary role, that you have the ability to be self-sufficient and have take that time ultimately.
So some people look at it in terms of a timeline, like, okay, well, she could just get a job in 3 months and do XYZ. And again, that might be appropriate, but as in almost everything family law, everything's looked at case by case because we're talking about people's individual circumstances. But I think the main thing for the payors of support to remember is that it has to be practicable. So
and within reason.
We can't just say that, and within reasonable time. Yeah, we can't just say, well, go get that education. If you have a couple of 6-year-olds, it might not make sense for you to be able to go have a second job to be able to support your tuition. Go get that education and just get a job in 2 years right after college and earn $100,000.
Yeah, and even earning $50,000 may seem like a stretch, especially if you've never worked in an area, like if you've never had that earning capacity.
If you've been off work for many years.
Exactly, and you have to upgrade your skills. It's very unrealistic for someone to expect, or maybe your job has just been entirely replaced by computers, or automation, some form in that way. But it's not realistic to expect someone to earn that capability. So yes, the objective is to promote self-sufficiency, but it is within reason.
And sometimes what we do, and again, I come back to collaborative family law because that's sort of where you're able to kind of tie these things in. Sometimes we say, okay, if your goal is to have this other party self-sufficient as soon as possible, well, do you maybe want to pay more spousal support so they can afford to go to college, for example? Or do you want to support them by paying for babysitting and allow them that additional time? It would mean more economic payout on the short term for you, but at least it allows the other party, the recipient, to become more self-sufficient quicker. Okay, so now that we've gone over what spousal support is, who's a spouse, and kind of the factors and the objectives of spousal support, let's talk about entitlement to the spousal support. So so what are sort of the three broad heads we look at when we're looking at entitlement?
So entitlement specifically, that's the most common thing you have to look at.
That's the starting point.
Yeah, so just because someone might not have the ability to pay doesn't mean that you're not entitled to spousal support. So when you're looking at entitlement, there's three bases to entitlement, and that's a compensatory element, a non-compensatory element, and a contractual obligation.
Yeah. So when you're talking compensatory, you're looking at, so with each of these, it's looking at your relationship and trying to figure out where it falls on the whys. And first, entitlement is the threshold question. If there's no entitlement to spousal support, it doesn't matter if you're a spouse, it doesn't matter if these objectives are all like great and all, but if you're not entitled, you're not entitled. So that's always the starting point of any spousal support conversation. And the basis on which you're entitled to spousal support determine things like the duration of spousal support, the amount you get, and things like that. So that's why entitlement is very important.
The first threshold.
People sort of gloss over it a lot, but it's just don't.
For example, if there's like a huge disparity in incomes, it doesn't, just because there's a huge disparity in income doesn't automatically entitle you to support, because you may not have that entitlement.
And if it does, it may not be on a compensatory basis. It may be on a non-compensatory / needs basis. So I'm going to say just needs because it's easier for me to say than non-compensatory. But it might be that you're not entitled. If you're entitled on a needs basis, then the amount of spousal support that you receive on each of these separate headings differ, right? So for compensatory, for the most part, and these are non-exhaustive factors, I'm just throwing things out there, you're looking at mostly longer term marriages that, or relationships, I should say, like relationships that have involved children, for example.
Yeah, hardship, loss of opportunity.
Yeah, did you have to travel out of town and support this, this other person's career choices? Just so kind of things like that, where you've subordinated your life to a larger extent for a longer period of time for the good of the relationship.
Yeah, so I would say that in the most simplest way to look at it is if you're that stay-at-home parent, taking on the majority of those domestic responsibilities and those child rearing phases, and going on maternity leave or paternity leave, things like that, and those loss of opportunities are where more your compensatory element.
So even on that compensatory, like on the maternity leave question, You might be in the workforce, but if you're the person, if you have three kids that are young and you've had to take maternity leave like 3 times, and the other party maybe took some paternity leave, but maybe a month or a couple of months, and you've taken a year and a half, you can't compare like the opportunities.
Yeah.
And
I mean, like, that spouse may have the one that, isn't staying at home and on that leave is getting promoted. And,
exactly.
Obviously you're not, able to network and get those advances in your career. So things like that definitely are more on a compensatory element.
So on the non-compensatory, on the needs,
so non-compensatory, we call it the needs basis for support. And this is really to assist the other spouse in need and capacity to pay. So, for example, the most common one is if the other, obviously if there's an income discrepancy, but again, this is with a needs entitlement. But
on a needs basis,
yes. So say one of the spouses is maybe sick or disabled or something of that nature, and there's a clear needs basis to entitlement.
Yeah, so they might not. So maybe there's no other. It's just the fact that they're ill, sick, for disabled, for example, is the only reason. Or this is where usually sort of that lifestyle or standard of living factors in. So maybe it's a shorter marriage. There's all of those other elements are for a compensatory basis are present. But just the loss of the standard of life that you're used to in and of itself could entitle you to spousal support on a needs basis. Contractual is just contracts. Is there a contractual basis for you to be entitled to spousal support? A written contract is great, but it's not necessary. An example off the top of my head would be, say, one person supported the other spouse through medical school, and there was always an agreement that you would support the other one through law school, for example. So where sort of that agreement exists, and that's a contractual basis.
Yep, it can be expressed or implied. Another is an agreement, like a cohabitation agreement, so a marriage contract and things like that you've already established that you would be paying a certain element of spousal support upon the breakdown.
So as Sherine mentioned earlier, your ability to pay has nothing to do with entitlement. And so if you're entitled, for example, on a compensatory basis, and even though when we do the numbers, actually before I go into that, an easier way to do that would be to start by talking about the effect of child support on spousal support. So when we run the numbers and do the calculations, there's times where if there's a child support obligation, because of the payer's income, we might see a zero amount for spousal support because child support trumps.
Is taking the priority. And that's the thing, is they're going to put the importance on the child over spousal support, unless we restructure the calculation. But ultimately, if that's where the focus is going, is if there is a child support obligation, it doesn't mean that there's no entitlement, but it may be there's no ability to pay after that payer is also paying child support.
Exactly. So that's, in those cases, how you deal with it is totally up to you and your lawyer. But when I see a strong compensatory basis and a lack of ability to pay, I usually just make it clear that, okay, for now, we recognize that there's no ability to pay, and we can deal with it later in the context of a review or variation, which we will talk about later. So in determining sort of the amount that you receive, if you're probably thinking, okay, so we've heard all of this, how much do I have to pay and how do I figure that out?
Or how much do you get if you're the recipient?
Yeah. So there's different factors that go into determining that. One is the length of your relationship. So that's a factor in the duration of support. And usually when, I think this is a good part to talk about, the Spousal Support Advisory Guidelines, the SAGs. It is not law, it is a guideline. You're not required to follow it, but honestly, if you set support outside of the ranges, there better be very good reason.
Yeah, they don't
very
really go
reason.
Outside of the SAGs, which is the Spousal Support Advisory Guidelines often. So while it may not be mandatory,
it is kind of mandatory.
Just like, for the federal child support guidelines, they are mandatory when we're looking at child support. The SAGs are more persuasive, but when I say they're more than more persuasive, Yeah, you better be looking at the SEGs when you're looking at entitlement and obligation and duration.
Because remember how we talked about the objectives, right? So if you pay something that's just way below what is required under the SAGs, then there's that concern of whether the spousal support you paid, did it meet the objectives of the of spousal support, right? So that's why we would generally not advise you going out of the SAG ranges again, except we're restructuring and there has to be reason behind it.
And so, for those wondering what SEGs are, it really are like they're calculations that will actually input, like once we put in the information about your length of relationship, the amount of children you have, your ages, would actually generate a formula for us to work with.
Yes. Yeah, so with the calculation, it would usually show us what the duration would be, and this is again all based on the law. So the output is all based on the law. Generally, we know that for shorter marriages, the duration would be shorter. For long-term marriages, for example, that you're definitely looking at an indefinite duration. Sometimes I would have people come in after 20, 23, 24 years of marriage, and they're like, well, I want to have an end date on so and so date, and I could tell them straight up, it's not going to happen.
At least they acknowledge they have to pay. So I usually get I'm not paying.
Okay.
I don't want to pay anything, and I'm like, that's very unlikely unless you have an agreement. Reality is, but there are ways to reduce the obligation, but again, with a longer marriage like that and with the ability to pay, you're going to have a tough time saying that you don't want to pay.
Yeah, or you want to pay for a limited duration. So when I find cases where a person is the duration is very important to my client, then I'm more inclined to make sure that we settle this with a separation agreement versus going to court, because guaranteed no judge is going to give you an end date with a long-term marriage. The best you could get is a review, which is not even likely. They probably would just say return when there's a material change in circumstances. But if we're lucky, we could get a review. So where duration is important, that's you want to think negotiation. I want to settle this.
You want to know
you want to negotiate
you can have
a settlement,
fixed sum or an automatic review period. But definitely, I imagine the end date is obviously the most preferential for clients who are the support payers.
Yeah. And so when we with the SAGs versus child support, your child support just gives you the amount you're to pay based on income, and that's that. With spousal support, we get a range. It's not a fixed amount. So you have a low range, mid range, and high range. A mistake people often make, even though it's been hammered down by the courts oftentimes, the midpoint is not, you don't have to pick the midpoint. So that's not the right point. It doesn't have to be compromised. There's factors that go into the low, mid, or high. So if you have a higher compensatory basis of entitlement, for example,
we're looking
at more at the higher end. If you have, maybe
short
children
or
shorter duration, you probably could go towards the lower end. If you have children that are primarily even in both parents' care, for example, and you want to make sure that you have sort of the same quality of life in both homes, then you go high. For some reason, people just think they have to default to the mid. Again, it's great because it saves the argument one way or the other, but there's nothing, it's not a magic number. You have to, it's a legal argument as to where you fall in your within the range. Yeah. So another thing, that goes into the conversation of how much support is going to pay, of course, is the income of both parties. We've talked about range and all of that, but really your income is the bottom line. What's your income for support purposes? If you're an employee, you're looking at line 150 of your income. Generally for everyone, we could go with line 150 because it encompasses your income from all sources. But as your lawyers, we know that, certain incomes,
like your business income or
your rental
income,
there's room for
tweaking.
Yes.
There's room for tax
and we're not saying anything illegal is going on there, because you are allowed to do that under the Income Tax Act. But for support purposes, we're obviously, exactly. That's the easiest way to look at it. So we'll be looking at all of your, different, if you have a business, the financial statements of the business and things like that. Just every source of income to make sure that we have a reasonable amount for your spousal support calculations on both sides. And obviously, from your income, you're entitled to certain deductions. Obviously, if you're paying union dues, in some cases, maybe some mandatory pension contributions, again,
yep, if you're withdrawing
you could
from RSPs,
make that argument.
sometimes you can claw things back. If you're receiving foreign income, that may be taxed and grossed up. But honestly, if you're looking at income in general, you may want to consider Section 7 expenses that you may be paying towards the children. That those often, depending on the amount, can actually reduce the amount of spousal support paid, because it's factoring in, again, the importance on the children and the ability to pay based off those amounts that you're also paying. So if you're paying a significant, maybe $10,000 in daycare fees, I mean, this is after tax credits, so taking into consideration that, but post-secondary expenses and things like that would also be a factor. And then I guess just determining that, you would maybe look at the net disposable income and then look again at the ranges. So really, what the most appropriate range is. Yeah,
so for me, the NDI, obviously I always put an eye on the NDI, and depending on the NDI is net disposable incomes.
What does that actually mean? Because I have explained, I obviously know what it means, but I mean, for our listeners, I think it may be important to actually understand what net disposable income means.
One of the biggest challenges that support payers have is, how would I survive? If I tell you that you're paying $5,000 in spousal support, automatically you're thinking, well, I net $8,000. If I pay how can I pay? Not even aside from that, how can I pay her more than I'm getting? And that's the way they're looking at it. This is I know I'm making $10,000, but I'm really not getting this amount. So the net disposable income takes into consideration all of your sources of income, takes into consideration both parties' tax positions, and can show you what percentage of the family income would be left in each hand. And I know I've done videos on this but I just can never emphasize this enough. Don't panic too much about the gross amount of spousal support you're paying. This is where the NDI considerations, or this is where the tax, because of the tax treatment of spousal support, given a choice between spousal and child support, I pick spousal support anytime, because a portion of your spousal support payment is tax deductible to you. So once if cash flow is a concern, you can sign the relevant forms, and your employers, for example, would reduce the amount of source deductions that are taken from your income, so that even though you're paying out this large amount, it's not just that amount it's not that amount you're actually paying out, because there's tax treatment of the amount. And the reason, in its simplest terms, is because while spousal support is tax deductible to you, it's taxed in the hands of the other party. So again, the NDI looks at, when you pay that $5,000 to her, if she's paying $2,500 in taxes, how much is actually left in her hands versus in your hands? And there is no magic number, except, there's general rules of thumb, right? So if the children are 50-50 in both residences, then obviously you're inching more towards...
Yeah, one's claiming the dependent credit, the other one would be claiming the child tax benefit, depending on
it all goes into the NDI consideration.
All factors in the net.
No, what I was trying to get at is, if it's a 50-50 share parenting arrangement, then you're looking more at closer to a 50-50 NDI split. So it's how much of the incomes are you splitting? Because if you have children living in both places for equal amounts of time, it really doesn't make sense from a legal perspective for one person to have just 20% of the net disposable income and the other person has the rest. It might be fair because you're making more money, I understand that, but from the perspective of what works best for the children in that case, it might not be appropriate. And obviously children are not the only reason. Long-term relationships, being accustomed to a certain quality of life is also a factor. and things like that. We had already touched on the fact that, if it's with or without child support formula, that all goes into the net disposable income consideration. If we weren't clear, child support is neutral. There's no tax treatment to child support. You cannot deduct child support from your income. It's only spousal support that you can, and obviously it's the other party doesn't get the full amount, free and clear. They have to think about taxes for themselves as well. So I mean, I guess I'm thinking, what are sort of options? So now what, you've done these calculations, you kind of see the different numbers, percentages, and it could really get overwhelming sometimes, but it's worth it, because again, if you're going to be paying this amount for any number of years, you're better off just doing the hard work now and really having that conversation. It doesn't have to be conflict. It's a conversation about your entitlement, about where in the range you should fall. The location in the range, if it's low, mid, or high, would affect sort of the NDI that we're looking at. It would also affect the taxes each party has to pay. So it's all part of the process. And it would also you would look at the duration. And this is kind of where you can restructure your spousal support, where you can say, okay, I would pay a lower amount for a longer duration, right?
Or a higher amount for a shorter duration.
Yes.
This is where that negotiation aspect comes in. So let's say, maybe the spouse is like, in 3 years, I think I'll be fine. I can do what I want to do, and I think I can be at an income where I feel comfortable, not needing any more support. So you could actually restructure the scenario to actually have only 3 years, and then it would generate a number, and then you would pay that.
Yeah.
So you could force certain scenarios, and that's what we mean by restructuring. So if you want to pay longer or shorter with the duration, and then, changing the amounts.
Because sometimes there's free online tools where you can go calculate your support, and it would spit out sort of this low, mid, high numbers. And people get overwhelmed with that and all of that. And we say, just don't. That's part of our jobs. We may not be able to get you out of not paying spousal support. We will try if it's appropriate, but in some cases it's just not supported by the law, and you will have to pay that. But that's where we hear your concerns. That's where we
find other ways.
Yeah. So if debt, you might be leaving the relationship and coming out with a lot of debt, and cash flow is a problem at that time.
Yeah.
So, maybe what if you pay a little bit of a lower amount to start, and the other party, if maybe the debt was incurred, for example, to pay an equalization payment, well, you're not hurting for money in the short term. So how about we extend it for a longer duration? But even a favorite one is the lump sum, right?
A lump sums I like, if obviously it's nice because it's clear and cut. Unless you've restructured your lump sum as well to be payable over a certain period of time. But ultimately, people also like lump sums, and this is usually where they have the cash flow. Let's say, for example, they're selling the home and they're okay. Maybe what the other party's buying the other out, so they would take a little bit of a less of the equity because to account for the lump sum. What I like about the lump sum is that it discounts for taxes, so it's.
Well, it's not automatic. Well, not automatic. It's not automatic, because what a lot of people, Sherine, you're looking at it from a lawyer's lens. You have to understand that for most clients that talk to me, when they think lump sum, they say, well, we've done this online calculation. I know I need to pay her for 9 years. And then they take their calculator and they calculate the amount they're supposed to pay per month, multiply it by 9 years. And that's not the case, because you're losing by paying a lump sum. You're losing the tax deductibility that you would get, because if you pay a lump sum, CRA doesn't allow you deduct it from your taxes. Yeah. So what we do is we discount it for taxes, and that's what she remembered when she was like, well, you already took the lump sum. So she jumps to the end, forgetting that some of you may not have the tools that she's using, right?
Yeah, so discounting it for taxes is obviously a popular choice. But there's also different ways to set it. Like for a lump sum, let's say, for example, you have even a pension that you wish to pay out more than they're entitled to. So things like that, different ways to restructure a lump sum. You can use it from the property. Hopefully, if you have other assets available, you can pay it out that way. But at the very least, like that's a more very
Some
clean.
people like that because it's clean. I'm a fan of it for shorter term relationships as well. Like rather than just having to pay every month, just get it, just move on, just pay this lump sum and move on. But for some people, there is also a psychological element. Like they cannot, for the life of them, write that check every single month. So a lump sum is good
if
for
they,
them.
maybe didn't leave on the greatest terms and they truly just want to be done.
But what about the recipient of the lump sum? Because sometimes it may not necessarily be the best for you. So I also look out for my clients where they're the recipient. Of course, it's nice. I declare advantages. If anything happens to his judge or whatever, to his job, then it's not your problem. You already took your cash. If you can invest it properly, that's great. You got your cash, you dip, and you go, maybe make some interest and make more money out of it. It works out better for you.
So I'm guessing one problem with that being the recipient is if you need to show some sort of level of income to maybe qualify for a home, and let's say you're really not earning that much, and that, that $2,500 in spousal support a month would have helped you obtain that mortgage.
Oh, that's an interesting perspective for sure.
So that may be something that but again, getting a lump sum for $100 and XYZ dollars, I don't even know, but
it could help.
It could also help you get the down payment. So you can pick and choose. Kind of, or sometimes
I guess it depends on how you're getting the lump sum, because if you're getting it saved by way of an RSP transfer, you might not be able to pull out that much, and in that case,
you may not be able to touch that for until you're at least 55.
And even then, like the taxes, if you pull out so much,
exactly, you can only pull out a maximum withdrawal every year. So it's a lot of considerations, even if you're the payor or the recipient, that you want to consider when making these decisions.
And when also advising my client, that again, you need to know your client. If I have a client that, and no disrespect here, but if I see a pattern of either not being responsible with money or just doesn't or lacks the sophistication, I may not necessarily, I can't make the decision for them. It's theirs to make, but I'll let them know what they're involved in. So if you have the payor that's in a very stable job, has been there for years, likely going to be there forever, you may not want to take that lump sum, because I have concerns over, can they invest the money? What would they if it's someone that has, say, gambling addiction now, I get concerned on behalf of my clients as well, because if I just handed you, hundreds of thousands of dollars that could be gone, and now you're broke. And even if it's not your client too, if my client is the person that's going to be paying that lump sum, and you're telling me about this gambling addiction that she has, then that's something that we really want to be mindful of. Because even though there's rules around double dipping and there can be fine, we can put in a fine of spousal support release and things like that. You also know that the court still has that residual jurisdiction.
Nothing is so final.
That the court cannot interfere with it.
So that's one thing to know. It's like, and the one thing I recommend is like, sometimes people would come to me maybe having a separation agreement that only deals with like one or two issues and not the issue of spousal support. And they come to me saying, you know what, she actually doesn't want spousal support. And I'm like, well, let's add that to the agreement. Because the one thing you should know about spousal support, you can come to claim that at any time. There is no limitation period, such as property, which is like 6 years after separation and 2 years after a divorce. There is no time limit for you to bring your claim for spousal support. Yes. So, of course, the timing would be, the court would consider why so late. If
it might affect entitlement and things like that, but you don't need
definitely
that
want
nuisance.
to live like that.
Yes.
I'm like, honestly, if you want that clean break, you want to make sure everything's spoken to. Again, there's always so much finality you can have, but you want to be able to sleep at night.
And that spousal release could do that for you.
Could really change that for you, especially because most people don't know that, just because you had a verbal agreement, the other's not going to go after spousal support, that doesn't protect you. Or
if you're just silent on the issue of spousal support.
Exactly, that definitely doesn't protect you, because it doesn't show that your intention was to release spousal support.
Yeah. So, something interesting happened with me. This is probably about 5 years ago. My client was the one that was the higher, no, my client was the lower earning spouse, and the other side, we were, having this conversation about spousal support. And unfortunately, that the person that should have been the payer suffered, I can't remember what it was, maybe a stroke or something. It was a medical situation. Now we were in a position where my client would now may potentially be exposed to a spousal support obligation on a needs basis.
Wow. See?
So, ever since then, I don't like to leave loose ends. I wish everybody the great health and a long life, but I just don't want to be that person that left that loose end, and now all of a sudden my client, is on the hook for spousal support. So I want that release. I want it to be mutual releases. So I release you from any obligation, you release me, because the tables can turn, essentially.
Exactly. And you never know what can happen during, that period of time. Like, you could, before signing a separation agreement, the other party can get into a terrible car accident, and that can change their entire needs basis for support. So, again, in this world, never leave a stone unturned. You just never know.
Well, you in your morbid example, it's before they sign a separation agreement, so I don't even know if there's anything they could have done there, because that would just be unfortunate.
I guess, fine. In that scenario, fine. But just definitely put your mind to it. Don't think that, just because, you have an agreement, between yourselves, that you're not going to go after certain things. You want to make sure that you're protected each way.
Yeah. And on that, since we're talking all things dark, let's talk about security for spousal support. Because what if after you agree to spousal support, and this would, actually could apply to a lump sum if it hasn't been paid yet, or usually for people that are on periodic support payments. What happens if the other party dies, like as Sherine mentioned?
Part of our jobs as lawyers, especially with periodic support payments, is to make sure that support obligation is secured somehow. The most common way is life insurance. We'd find out how much of that obligation, how much of that policy you need to set aside. We may have review provisions for, lowering that amount as each year passes.
I think what Sherine saying, so people have a higher, like some people might have $1 million in spousal support, for example, and you don't have to name your ex as just the beneficiary to your $1 million. We would do the math and let you know she might be only entitled to $200,000, for example.
Exactly. So the policy value, you would actually designate your spouse or the recipient that's receiving the support as an irrevocable beneficiary, so you can't automatically change it. We would add provisions for replacement coverage if it's not available at the time of death, or
a charge on your estate. So if you die without that support, then remember it's binding on your estate. And you may or may not care, but if you care, just remember that your loved ones may be in a legal battle with your ex.
And the one thing you want to know is if your estate is paying spousal support, that's actually not deductible with your estate. So you may want to consider making sure that you have that support element secured. So again, like she said, like Angela said, there are security such in the form of a binding on a first charge against the other party's estate. You can even put a lien on a property.
Yes.
You can put...
Yeah, because some people get concerned about if you don't have existing life insurance and you're older, if it's a great divorce, and you don't want to get
be very expensive, which is where my clients really like the lump sum approach, because oftentimes it's just paid out and there's no security.
But if they have a home, we could just, put a lien, some kind of collateral, mortgage or something on the home.
You can even designate them as part of your beneficiaries for your RRSPs for a particular amount. So there's so many different ways to restructure it if you need it, and if life insurance is too costly.
Don't be freaked out.
But know that it is an obligation that you do have, and you definitely don't want your estate to be dealing with that. I mean, I would just say it's simpler when you're dead because you don't care, but you definitely want to keep that in mind.
But if you're leaving people that you love, if you're in another marriage, for example, and you have other kids, you want to make sure everyone's provided for, right? Even when you're gone, the last thing you want for them is to be in a costly legal battle with your ex. Like, especially if you were in a legal battle while you were alive, you don't want that happening again while you're dead. And these things can be dealt with very easily. We just need you to put your mind to it on an ongoing basis. So now, sorry, Sherine, did you want to add something?
There was one thing I want to talk about, which was post-separation increases in income.
That's exactly, great minds. That's exactly where I was going. That's exactly what I was thinking. I'm like, well, when we have that periodic support, what happens when your income goes up, right?
So the common misconception is that people either want to review support every single year, which we never really
No, I don't really like it. Yeah,
but also there's no automatic entitlement to any increase in that other payer's actual increase in their income. So say 1 year they're earning $100,000, the next year they're earning $200,000. There's no automatic entitlement for you to be receiving support based on a $200,000 income versus that $100,000.
Yeah. Could you potentially be entitled? Maybe.
Yeah.
But we have to set it out. So if for whatever interesting reason, the lawyers, because clearly Sherine and I are not fans, we like finality. We like to wrap things up nicely, put a bow on it and be done. Of course, it's not always possible. If for whatever reason, a review is appropriate, then we when we review spousal support and review that greater amount, again, as Sherine said, we don't just automatically just take the 200,000. There's factors, right? So is it the same job and you just by chance just got promoted within the same company? Then in that case, maybe there is some entitlement if your ex helped you get to where you were at the time of separation and you've had to do nothing extra. But if you've done some extra trainings, if you've changed jobs,
this is like maybe 2 years, 3 years down the line, like the entitlement would be a little less.
Yeah, no, I have argued even with time that there's still entitlement, because if you're in the same job, I'm saying, well, you're enjoying this higher income because of all of the effort that my client put in over 20 years of marriage. So I don't care if it's 5-10 years later, I think you're still entitled. Where I draw a distinction for my clients that I don't want to pay a higher amount is I say, well, he's done XYZ training. You weren't a part of that training. You weren't a part of, I don't know, of him networking and finding a new job.
Traveling and securing better networking and getting different contracts and things like that. Yeah, fair enough.
So you may or may not be entitled to the post-separation increases, but the point again is these things are not automatic. You need to show entitlement. You need to put your mind to it. And, if you're that person that's increased your income, don't think you just automatically have to give out this blank check. Just put your mind to what you're doing now, and is that person really entitled to, that increase? And even on that note as well, sometimes I wanted to kind of talk about, I don't know if to call this double dipping, but I guess that's what it is, I guess.
I think it's the easiest way is to double. I think that's the easiest way to
Yeah, because if my client split their pension with the other spouse and now...
As part of equalization.
Yeah.
And then now they're dealing with the issue of spousal support, maybe on a review.
Post-separation, and my client's income is just solidly based out of that pension that's already been divided.
It may not be appropriate because you're using both income sources. You're basically double tapping into the same income source.
Yes.
Both at the time of separation.
So at the time of separation, you got it as property in equalization, and then now you want to still get that same money as support. Long story short, you're most likely not going to be successful in that case.
There are ways to work around it.
Of course, there always are ways. Oh.
So that's like looking at the factor of like maybe if your income's only comprised of pension income earnings, then you may look at the part of the pension that wasn't equalized and what that actual income is. So that would require an actuary to actually determine what those income sources are. But you definitely want to keep your mind open that you don't just automatically get to double dip tap into the same income source that you did as part of.
And if you're the person that's trying to resist double dipping, well, your argument could also be, well, I want to know what she did with the capital that she received, right?
Because the recipient also has the obligation to basically invest those monies and make the same self-sufficiency, but also to income generate those exact same assets that they received upon equalization.
Yeah, so that's the point. Like, remember we talked about one of the objectives is to promote economic self-sufficiency. So taking that money, and it's because of over the years and sort of things that have happened in my experience that made me, think of things like, how is this person going to use this lump sum capital, for example, because then you give it to them and it's not impossible that someone just squanders their lump sum and then they are back needing support, and then the courts again and having this conversation about entitlement and whatnot, and you know, policy reasons on why you may need to pay. But that's a totally different podcast. I'm not going to take us down that hole. But remember, as a support recipient, you have an obligation to become self-sufficient, and self-sufficiency is not limited to getting a job or getting a better paying job and getting training. No, investing your capital is one way that you're going to try.
Your income generating assets will form part of your income.
Yes. So, but let's talk about, you know, a situation where someone's done none of that. They've not tried to improve themselves, even though they have the opportunity to, or they've just squandered their assets, or even just straight out refused to properly invest their assets and just relying on spousal support. Well,
again, that's where imputation of income comes into place, because again, the objectives clearly state that, you know, you have an obligation to be self-sufficient. As much as I would also like to sit there and receive a check every day, I also know that my obligation far extends beyond that. If I have the ability to, I should be able to be self-sufficient.
I like that you added the ability to, because in some cases it's not possible.
Yeah, like for some cases where you're permanently disabled and you really don't have the ability to just go out, if you have a debilitating you know, disability that doesn't actually just let you
even childcare responsibilities, actually.
Yeah, if you have a child with a disability and things that require more intensive, you know, home duties. I don't even think that makes sense, but you understand what I mean, that you're at home, you're required to be at home. There's things that limit your ability to actually be self-sufficient. That's fair enough. But I'm talking about in terms of purposely, intentionally being underemployed.
Yes.
And being non-self-sufficient. That's where the other party, who is the payor, would say, you know what? No, you have an obligation to be self-sufficient. You haven't even tried. Maybe you've never even done, you know, job efforts and search like things like that.
Or just might be underemployed. We know you're able to be in management, but you just choose to remain at an entry-level job because you don't want to extend yourself, right?
Yeah, and that's where the court would determine whether or not it's appropriate to impute income to you based on what we believe a person in your capacity and ability would be able to earn.
Yeah, exactly. Well, imputed income could also go the other way to the payor if you're
exactly.
If
but
we
you have
feel
to be careful.
If your income, if we feel like you're also being underemployed or you're underreporting your income. So let's talk about like review and variation of support orders, right? So these come up in the context of you already have, I mean, if you paid a lump sum, then good for you. You're done and you can move on with your life. But if it's a periodic amount and there's no end date, then yeah, you're looking at either a review or variation. And in the simplest terms, it's not the same thing. A review is you guys determine now that on a certain date we would look at support at the time, and at that point we can review the entitlement, this and that, the amount, all of the factors would review at a set point in the future. Variation, when we think variation, you're really thinking material change, having to show a material change in circumstances. So they're different. If you have an indefinite spousal support obligation, for you to terminate support or for you to even reduce the amounts that you're paying, you're going to need to show not just a change, a material change in circumstances. I'm not the biggest fan of reviews, and I think we said that already, but there's cases where it's appropriate, and yeah.
So like a very, foreseeable retirement date.
Yeah. Or even with COVID now, this is another good time that we could use reviews, because if a client is separating now and due to COVID, the payor's income is very low, well, maybe I don't want to have to show a material change in circumstances and have to prove that, the economy is now back up and things have improved.
Or maybe the economy has, significantly impacted your ability to actually earn the same. Let's say maybe you were earning a specific income and you're not sure if you can even maintain it. You maybe automatically do a review within a 1 year period, because there are lots of industries that are going to be separating when we start opening up. And,
exactly.
If you're lucky enough to listen to this this podcast during the pandemic lockdown that we're still in, but yeah, it's definitely a consideration. COVID significantly impacted a lot of those.
Yeah, and I think you were saying earlier as well, retirement. So if we can see that retirement is imminent, right? So if it's going to be, retirement can be a material change in circumstances, but if we already know it's going to be happening in 2 years, let's just have a review at that time.
I'd like to add it, so then it would be based on, the retirement income at that point, but again, considering what we've also talked about, double dipping, so we would go over those considerations.
Well, I guess my biggest concern with reviews, and it happens when payors are saying, well, for me, it happens more often in the context of my payor client not wanting to pay more in support. They're so convinced that the other spouse is able to earn more and should earn more, and they want to come back in 2 years and they want to. And my fear is,
like that.
and my only fear is we may come back and you may find yourself paying more.
Exactly. So it's a risk. That's definitely something that I would have to look at the circumstances. But I
if you're one of those people in a job where you automatically get pay increases, and there could be any number of reasons why the recipient has not improved on herself, and you'd be surprised the courts they're not going to do anything to her. Yes, they might suggest she pay more. They may not impute income to her depending on the circumstances.
And it may not be the income that you're thinking of.
Yes.
So it has to, again,
so imagine if you've had a $40,000 increase in income, or a $50,000 increase, and now the other person is imputed an extra $10,000. Like, you may still find yourself paying more.
Exactly.
So just be very careful when doing reviews. The material change for variations, obviously, a material change has to be something that
was unforeseen at the time. So, for example, maybe the payor became permanently disabled, got into a car accident, no longer earning income. That would be
industry wiped out due to
exactly.
COVID.
That's been the most common ground even now, just to vary support obligations.
But even to be honest though, even now, I'm not necessarily accepting COVID considerations as a material change. I could temporarily suspend it because we don't know, right? It's not a very. We don't know what's going to happen.
It's a temporary situation.
Yes.
So you may put a pin in it to review at a later date.
Yeah.
Fair enough. But it would also be a consideration where, especially during these past year and a half, where, if you're in restaurant industry and, you're not lucky to be one of these big box restaurants, that you ultimately maybe you were forced to close or claim bankruptcy and things like that actually permanently affected your ability to.
But look at let's say you got your income from, say, if you're a hotel owner, for example, and if we base support just on the last couple of years, it may look like it's going to be a zero amount or whatever, and that's fine. We could temporarily suspend support if it's appropriate. But I don't know if I want to call that a material change to terminate support or to permanently vary support, because, as we all know, everyone's itching to go somewhere. So the tourism industry, if the experts are correct, is going to blow up at some unknown point when the pandemic ends. So, but anyway, I think you get the gist of what we mean by material change in circumstances versus a review. A review is almost, I guess we could say, automatic. A material change, a variation due to material change, you have to show that it's material
enough to warrant,
and it's a change that's material. Okay, so when you have your support agreement or that support order, the ways, there's different ways you can receive your payments, I guess. You can get it through FRO, which is the Family Responsibility Office. Something you need to put your mind to, if you're getting it, if your support is as a result of a court order, you will automatically, your support would automatically go through the Family Responsibility Office, and you have, if you want to withdraw from that, you have to file the notice of withdrawal. If your support is based off of a separation agreement, for example, then you need to register, and you want it to be enforced with FRO, you need to register it with the Family Responsibility Office for
by filing it with the court.
By filing with the courts for them to enforce it. I love FRO enforcement because in my mind I'm thinking, if you've gone through this entire process to get to the point of getting your support order, the last thing you want is to also have to enforce it. FRO has wide enforcement powers that you may not be available to you as an individual to enforce. However, if you're the support payer, I'm not a super fan of flow enforcement, because terminating support that's going through flow can be a nightmare. It's
even sometimes when you're taking maybe a couple on, because it's garnished automatically off of your pay, depending on if you're an employee. And let's just say, for example, you took a month off of vacation or things like that, and you're automatically, you're operating at a less of an income off the top. I mean, some people like it because it's just coming off the top.
Yeah.
But at the same time, like most of the support payers don't usually like to go through fro.
Yeah, when we do agreements, we would, and the parties are okay with not going through fro, but we would usually advise that we put in a clause there that if you've not paid, if you're late by a week or a couple of weeks,
there's some penalty, there's some interest that accrues, there's some consequence to not paying for sure.
And flow enforcement
and flow enforcement would ultimately take place after some consistent non-compliance with the payment amount.
Yeah. So the last thing I want to talk about is the cost for spousal support. Or no, that's not the right way to put it. Okay, let me paint the picture here. So if you went through a court process to get your spousal support, and now you have that spousal support order, you've been successful and you've been awarded legal fees, the last thing you want to have to deal with is enforcing collection of the legal costs that you've been awarded by the court. So generally in those circumstances, I would plead with the courts to make the cost order a spousal support order. And again, this is in cases where there's no cash available to pay me to pay you out, right? So if there's a home that's being sold, chances are you could get the cost award paid out from there. There's other ways. But
that's very smart, because to be honest, sometimes spousal support survives bankruptcy. So for example, if maybe you know that spouse may have an intention to file for bankruptcy, then maybe you want to secure some of your costs, or even an equalization payment as some sort of support obligation. That would be a very wise choice to go.
Okay, so that's it today on most things spousal support, because I'm sure, as you can imagine, there's a lot that we didn't touch on. But this is our fundamental series, so we're trying to just leave you with the fundamentals. And except you have anything else to add, Sherine?
No, that's everything. If you ever do need some assistance or some advice on the issue of spousal support and whether you're entitled or if you're the support payer, and just considerations to consider, please visit our website at aprincewill.com, and I'm sure you can find some more information on where to find us.
Absolutely, and more free resources as well to help you as you conduct your spousal support research. And for now, I guess it's a goodbye, and talk to you later.
Goodbye. Thanks for listening and joining us in the AP Legal Zone. We hope you enjoyed this episode. You can find more episodes by searching AP Legal Zone on anywhere you watch podcasts. Be sure to subscribe to our podcast today so you can stay connected with any updates and get notified about any new episodes.